So Shepard versus the United States is one of the early efforts to use the Hillman doctrine to offer seemingly unlikely statements as non-hearsay to come in even though the declarant is unavailable. In this case, the declarant is unavailable because she's dead. It's Mrs. Shepard. And she claims, or the prosecution claims, that her husband has poisoned her. And in order to show this, they're showing her statement that, she says, Dr. Shepard has poisoned me. So how does she come to make this statement? She's been very sick. Her nurse hands her medicine. She takes the medicine, and then immediately after taking it says, Dr. Shepard has poisoned me. So that's her conclusion, much like we learned in the Phillips case, that it was the wife's conclusion that her husband was having an affair. The conclusion a person draws is not evidence. We don't know the process the person used. We don't know what evidence they relied upon to arrive at that result. So we cannot offer her statement that Dr. Shepard has poisoned me as proof that he actually had, that the vial of medicine she was handed contained poison. But the prosecution recognizes that. That's not their theory for admissibility. The prosecution says, oh no, we're going to offer this under the Hillman doctrine. But in what sense would this be Hillman doctrine? Dr. Shepard has poisoned me. What would that say about anything, about her intent and about her actions? Well, the defense had claimed that Mrs. Shepard was suicidal. And the defense had argued that she died not from poisoning, but from suicide. Both from a poisoning, but from different people, Mrs. Shepard versus Dr. Shepard. And so the defense, or the prosecution, wants to argue that when Mrs. Shepard says, Dr. Shepard has poisoned me, that goes to her state of mind. It's being offered to show that she did not desire to die, and therefore that she was not going to and had not poisoned herself. That this statement shows her state of mind, shows her actions. Now, this, the court says, is highly problematic because there was no limiting instruction given. That the jury was just told that Mrs. Shepard, as she's expiring, says, Dr. Shepard has poisoned me. This is really damning evidence for folks who are unfamiliar with rules of evidence and things that we should appropriately consider in homicide cases and shouldn't. I mean, it's pretty bad anyway. It really sounds like a voice from the grave accusing her killer. And Justice Cardozo says, look, you can't offer it for that. Well, at least you can't do it, he says, in the form that they did. That here, the jury was just given the statement, Dr. Shepard has poisoned me, and not told what to do with it. What if, though? What if the jury had been told, you may consider this evidence only as evidence that of Mrs. Shepard's state of mind, and that she would not have tried to kill herself? Could you offer it for that, for the Hillman doctrine? The fact that she says Dr. Shepard has poisoned me meant that she would not have tried to poison herself. And if you look at Cardozo's opinion, the answer seems to be yes and no. It could have been offered for that purpose, it seems. He seems to suggest that if we're simply offering the statement, Dr. Shepard has poisoned me, to show that she did not have the desire to kill herself, that she was not suicidal, yes, that would be an appropriate purpose for it. But notice how much time Justice Cardozo spends talking about the impact that such a statement would have on a jury. How the jury could not, in its mind, on its own, without a limiting instruction, in any way begin to cabin the purpose for which we're offering that statement. So the question would be whether, even with a limiting instruction, this statement could come in, or whether the statement is so prejudicial that it substantially outweighs the probative value of her non-suicidal intent, the only purpose for which we can offer it. And it definitely seems like Cardozo is saying this would fail a 403 balance in a world where 403 hadn't been codified, but it would have been part of the common law understanding. This case predates the rules of evidence by like 40 years. But the takeaway from this is that he does offer this as a valid theory, that a statement like Dr. Shepard has poisoned me could in fact be offered to show that she was not suicidal, to rebut the defense's claim that she was. But in all likelihood, he seems to also be saying, yes, while it could be offered for that valid purpose, the threat of misuse, even with a cautionary instruction, is likely to require us to exclude this piece of evidence. So key takeaway, if you're going to bring something like that in this case, it has to be for a purpose other than showing he actually did poison her. It has to be for some purpose for which her state of mind is relevant, and her desire to keep living is relevant if the defense's theory is suicide. But it also shows you how creative you can get with this Hillman doctrine. The fact that a person's state of mind can be shown can be offered to show that a person acted consistent with that state of mind is a very powerful exception to hearsay, and will have all sorts of applications that will seem unlikely, because the statements will seem so much like hearsay when you look at them. And in fact, they are. This is simply an exception to hearsay, where we think that people are honest or are more honest about their statements of their future intent than they would be in relating historical events or currently existing facts. So key takeaway, you can use very creative theories under the Hillman doctrine to offer statements that show state of mind about future intent, to show the person acted later consistent, or in this case, didn't act in a certain way consistent with that state of mind.